So welcome again. My name is Karen Davidson. I'm here with my colleague Armando Gonçalves. We're here today to talk to you about employee share incentives, focusing in particular in relation to private companies. What we aim to talk about today are firstly the benefits of establishing and operating an employee share plan within a private company. Things that you ought to be thinking about when you're working out how that scheme is going to be designed. And then we're going to look at three particular types of share incentive plan that we see private companies adopting. So we're going to look at EMI first of all, and then we're going to have a brief look at unapproved plans and growth shares in relation to that. So first of all, what are the benefits of share incentives? So Armando and I work with companies to design and implement share incentive plans across a wide spectrum of types of company, but they tend to have very similar aims and objectives, and those are these that are noted on this slide. So firstly, setting up a well-designed share incentive plan can act as a brilliant incentive to get employees to help grow the business. So it increases their engagement and motivation to help grow the business. Also, it's widely reported that those participants in share plans have a feeling of belonging with the company when they're actually involved in the equity. And that helps to increase the retention of those employees. So they're less likely to leave and move to competitors if they have that sense of belonging to their company. And often plans are designed in order to try and hook into that retention benefit. They are also used as a reward for past service, so it's not all about future growth. Sometimes they are used as a reward for service that has already been performed. And it's particularly good at aligning goals with shareholders. So particularly if you have shareholders who are looking to try and grow the business with a view to exiting in the kind of medium to long term, then providing a share incentive kind of sweetens that for employees. Although they might be slightly unsettled at the prospect of a future exit, having some equity in the business actually helps to sweeten that and aligns their goals with the shareholders. And finally, but by no means the most important thing, you can create a scheme that is tax efficient. And so it's a good way of remunerating employees in a tax efficient way. And it's important to point out that simply providing shares to employees or directors can incur tax consequences. So if you give shares at less than market value to your employees, that is an employment benefit, which is subject to income tax potentially under PAYE. So a lot of these schemes are designed in order to try and make the scheme more tax efficient to provide shares to employees. So just moving on to the next slide. What do we think about when we are designing a plan? So we've put some kind of thoughts on this slide, but the main point I think is that no company has exactly the same requirements in relation to share incentive plans. So there's no one size fits all, and there is a danger on grabbing off the shelf schemes that is not actually going to be appropriate for your business. And another thing to think about is that although the company may be relatively low value when it actually sets up an employee share incentive plan, if you discover after having adopted a plan that it actually isn't working for your business, there may well be significant value in the plan at that stage, and changing the plan can actually prove to be very expensive, both from a tax and from an employee relations perspective. So it is really important to really think about how you're going to design that scheme and understand how it is going to meet your business goals. And I think the important point also to remember is that although tax is an important driver in these plans, you shouldn't let the tax tail wag the dog. So tax is important, but it shouldn't actually be the underpin for all of your share plan design. So have a think on the next slide. There are some things to think about. Are you looking for employees to access existing value in the business, or is it all about future growth? Do you want there to be performance conditions attached to employees being able to benefit from share incentives? And if so, will those be tailored to the individual, or will they be corporate wide? Will there be different ones for different tiers of employees? How much flexibility is needed in terms of the plan? Do you need there to be some flexibility to give certain awards to certain classes of employee, and others to others? And are you planning to do a one-off award grant, or will you be regularly making awards? And you also want to be thinking about how you're going to deal with the unfortunate situation when employees do wish to leave or are forced to leave for certain circumstances. So how are you going to treat those in relation to the share incentive? And on the next slide, we have some other key conditions or considerations that you want to take into account, where you have a group structure and you've got different employees within different parts of the business. Which entity is it right to have a scheme in relation to? If you're setting up a tax efficient plan, you might be obliged to use the top company in the group, but if not, there might be some flexibility around that to be setting up plans in relation to subsidiaries that target performance in certain areas. You also want to think about the liquidity of the shares if you're using a share incentive plan. So there's only a share incentive works best if an employee can see when it's actually going to be able to realise value out of that share incentive plan. So if you're offering them an ability to buy shares in the company, how are they actually going to realise value? Are they going to be able to sell those shares? And that really comes down to whether there is anticipated to be an exit in the future. And if not, how can you create a market in those shares? And some careful consideration needs to be thought around how that would be done. If you are expecting employees to acquire the shares before there is an exit, are the rights of the shares that you have at the moment suitable, or do you need to create a separate class of shares? And what rights should those shares have? Should the employees be entitled to vote? Will they be getting dividends? Is there likely to be any dividends? And all of that needs to be taken into account in working out the design. And particularly important if you are looking for there to be an exit of the business, a sale of the business in the near or medium term, make sure that your incentive arrangement is designed in a way that can deliver a clean exit to the buyer, and you're not going to have residual shareholders, employee shareholders sitting there. Are shareholders comfortable with the level of dilution that is going to be incurred as a result of your share incentive plan? Do you need to get shareholder consents? Are there institutional investors who need to consent to the scope of the scheme? And finally, what will be the tax efficiency of the particular design? And running across all of those is a consideration of whether you can actually use real shares in relation to your plan, or should there be a cash plan which is actually based around the value of shares. So all of those considerations need to be taken into account. So on the next slide, we look at what's on the menu. So we're only going to talk about a few of these today, but there is a wide range of share incentive plans out there. You can do many things with cash bonuses. Those can relate to the value of the business, to the value of shares, or simply just based on performance of employees. So that is the kind of most flexible arrangement, but clearly not very tax efficient. You can actually issue shares up front to employees at market value or at no cost, or at an undervalue. There are tax consequences of doing that, obviously. You can grant options under the Employee Management Incentive Scheme. You can grant unapproved options, and you can grant growth shares. We're going to look at those three arrangements. And there are other all-employee tax advantage plans where you can't pick and choose which participants are going to be involved. So share incentive plans or SIPs, and save as you earn plans or SAYE are examples of those. And there is also a form of tax advantaged discretionary plan, a CSOP, which used to be called approved plans. That are in scope as well. But today we're going to take a more focused look at EMI, unapproved and growth shares, as those are the ones that we see predominantly in private companies. So Armando is going to take you through the benefits and the kind of particular design considerations for EMI schemes.
Thank you, Karen. So EMI continues to be the most flexible tax advantageous plan on the menu. and will tend to be your first port of call when looking for a plan that fits your design criteria. It's geared towards smaller, high-growth companies, which involves the grant of options over ordinary shares in a qualifying company, a qualifying employee, for the purposes of recruiting or retaining an employee. And next slide, please. There are financial limits on the grants of options. So a maximum of £250,000 worth of ordinary shares can be under EMI approved C-SOP options per qualifying employee. If an option holder holds EMI options over shares up to a maximum of 250,000, there are some restrictions that may need to be considered. A maximum of £3 million worth of shares under option can be granted by the qualifying company or by the holding company of a trading group. Next slide, please. So what is a qualifying company? Is a company which is independent. This is not a 51% subsidiary or otherwise under control of another company or another company and any person connected with it. There must be no arrangements in place for the company to fall under control of another company or become a subsidiary. A company which has or whose group has at the time of grant of the option not more than £30 million gross assets. A company with less than 250 full-time equivalent employees. HMRC considers a 35-hour working week should be taken to define full-time work for these purposes, and non-employed directors count towards this limit. Next slide, please. The company exists to carry on a qualifying trade and be trading or preparing to trade and does not carry on non-trading activities to a substantial extent or the holding company of a trading group. The company does not carry on any excluded activities to a substantial extent. And there is a list of non-qualifying activities in the legislation. HMRC has some guidance on what constitutes a substantial extent, broadly 20% of turnover, management time, and assets used for the business. But which measures apply will depend on the facts and the context. The company or one of the companies in the trading group, which with a qualifying trade, must have a UK permanent establishment. The company owns more than 50% of the ordinary share capital of all its subsidiaries, and its subsidiaries are not under the control and no arrangements to come under control of another party. HMRC will offer advance insurance on qualifying company status if there's any doubt. On due diligence exercises, some buyers will ask to seek advance insurance and can get difficult if one has not been sought. But this is key that there is no requirement to seek advance assurance and may not be appropriate in some circumstances. So qualifying employee is one who does not have a material interest in the company, a beneficial interest in or control of more than 30% of the shares or entitlement to more than 30% of the assets on a winding up or other distribution. Shares subject to any other option held by associates are treated as being beneficially owned for this purpose. An employee who is employed by the company and either works at least 25 hours per week or at least 75% of their working time is for the company if they're employed elsewhere or self-employed. A non-executive director is not qualifying for these purposes. Next slide, please. So now looking at the requirements for the option. So there are requirements on the terms of the option which must be stated in writing. And we do come across occasions where these are not met, and so options don't benefit from the beneficial tax treatment. The option must be capable of exercise within 10 years of the date of grant, and they do lapse on the first anniversary of death. There are additional compliance requirements, but we shall look at shortly. Next slide, please. So EMI is extremely tax efficient if the above conditions that we just seen are met. So where the option is granted at an option price equal to market value at date of grant, there is no tax payable on the grant of the option, and there is no tax payable on the exercise of the option. On the sale of the underlying shares, capital gains tax is payable on any gain above the option price. Business asset disposal relief is available in relation to the disposal of an EMI option share, provided that the option was granted at least 2 years before sale of the shares and assuming that the option holder is still employed at the time of the sale. Business asset disposal relief basically brings down the capital gains tax rates from 20% to 10% on the first £1 million of lifetime gains. So basically, the tax impact is the same. In fact, it's better given business asset disposal relief is given automatically, as acquiring the shares at market value when the option is granted, but without the need to buy the shares until there's a guaranteed exit. One thing to note, though, is that if the way in which the option holder realizes value is by way of a share buyback, it is likely that they won't get capital treatment on that disposal. So do take advice if that is ever the intention. Next slide, please. So where options are granted below market value, there are still tax benefits if the option price is below that market value on the date of grant. In those cases, exercise of the option do attract income tax and potentially PAYE and associated employee and employer NICs on exercise of the option on the difference between the option price and the market value of the shares at the date of grant. So any growth above that should be taxed as capital. Next slide, please. So looking quickly at compliance, this is an area where we also see some issues that can arise. EMI options must be notified to HMRC by 6th July following the end of the tax year of grant using the employment-related securities online service. Even if the option has been granted by someone other than the company, for example, an employee benefit trust or another shareholder, the option still requires to be notified by the company. In order to be able to do this, the company will need to register the EMI scheme. Because it can take up to 5 days to register a scheme, it is advisable to do this as soon as possible because it's not possible to notify the grant until the scheme is registered. If it's not notified on time, which is key to do, it won't be a qualifying option. If that is the position, it will depend upon how the option agreement has been drafted as to whether it will be an unapproved option or whether it will be not treated as a valid option at all. Each year, the company required to file annual reports of events relating to the EMI options at the same time as any employment-related securities online return. And next slide, please. Here's a summary of the pros and cons. Obviously, you have the slides for yourselves, but just highlight a few. It is discretionary, meaning that the company can choose who to award the EMI option. It is very tax efficient and can be exercised at, for example, at an exit event. Some downfalls: it is extremely important that the company meets the qualifying conditions and that the agreements are drafted in accordance with the legislation. Failure to do so will result in the option not being a EMI qualifying option. Karen will now discuss the bear traps we usually see in practice in the following slide.
Thanks, Armando. So we do see a number of kind of persistent issues in relation to EMI, both in terms of companies that are setting up their schemes, but also when we're doing due diligence as part of a sale process. So it's always useful to kind of know about these in advance. The kind of most prevalent issue is where a company has always had in mind that it was going to set up one of these tax efficient plans, just hasn't quite got round to doing it. Basically, you get the best tax efficiency for an EMI plan, the lower the value of the shares at the point that you grant the options. And so you want to be setting it up when the company has limited value if you possibly can. So the longer you leave it, the more value that accrues into your business, the less tax efficient these options are going to be. And certainly if you wait until there is a kind of sale in prospect, you're likely to get very little tax efficiency at that point. So leaving it too late is a significant one. Arrangements under which the company could come under the control of another company is another one that we see kind of causing issues with EMI quite frequently. Poorly drafted options is a real problem. So they're not quite doing what was intended and need to be amended, or alternatively you get to a sale and actually they're not delivering or delivering too much value. Either of those are a problem, because trying to change EMI options after they've already been granted can be problematic and trigger tax charges in certain circumstances. So it is worth kind of getting them right at the outset. Similarly, if you make the performance conditions too restrictive, changing those can be problematic after the option's been granted, and not complying with the various considerations that Armando had included in terms of the qualifying conditions is a problem. One other thing to watch out for is other shareholders' business assets disposal relief. Don't forget, if you're granting options, that will dilute everybody else's shareholding. So you don't want to be causing other shareholders to drop below a 5% requirement for them to get tax efficient sale of shares. So just onto the next slide, we'll have a quick look at a couple of unapproved plans, because if you can't qualify for EMI options, these might be what you look at next. The first one is just granting straightforward unapproved options. These are the most flexible provisions to make. The world is your oyster in terms of how you want to structure these, but they are not tax efficient. So what are they? They are basically an option where the employee can acquire shares in the future at a set price. They can be granted by any company or by any person. The exercise price can be any exercise price, although there may be a requirement for it to be nominal value if it has been granted by the company, which can't issue shares for less than that. They are often used as a top-up to tax advantage schemes. So if, for example, somebody has already bust through their £250,000 limit for EMI, or you've been granting CSOP options and they've exceeded that, you might want to grant unapproved options as a top-up. And there are no real requirements as to what needs to be set out in writing. It could just be a certificate. It could be an oral contract, but I would advise against that, so that there's some clarity around what the terms are. And the next slide, we're just looking at what the tax impact of those are. So like EMI options, there won't be any tax when the option is granted. So you can grant an option and there's no tax effect. But when the individual comes to exercise that option and acquire the shares, there will be income tax on the difference between what the market value is when they exercise and the option price. So that little bit in green there that says income tax, that's what would have been sheltered under an EMI option from income tax and would be subject to capital gains tax only. That is subject to income tax under an unapproved option. And so there isn't really any tax efficiency built into an unapproved option at all. Your business asset disposal relief is less likely simply because they would need to have 5% shareholding. They would need to have that held for 2 years after the option is exercised and meet all the other conditions. So there's no automatic relief like you would get under EMI options. The company may well get a corporation tax deduction in relation to the option case. So there are some benefits to granting it by way of an option, but it's not terribly tax efficient. But on the other hand, on the next slide, we do say that they are very compliance light, so it's really easy to establish these. They still need to be registered with HMRC, and you still need to report those grants, etc. But you don't have the same considerations around qualifying conditions as you would get in the other scheme. Just taking a quick look, we'll skip over the next slide because I think we've probably dealt with the kind of pros and cons of unapproved options already. Onto the next slide, which talks about growth shares. We're just going to touch on these because they are a bit more complex, but it is useful to know that if you don't qualify for EMI options, you can set up a similar type of arrangement from a tax perspective, but it's not similar in reality, by issuing what are called growth shares, which are shares that are issued to employees for a price, where they only are able to participate in the value of an exit above a certain hurdle. So the idea is that although they get shares up front, they're not really worth an awful lot when they get them. And because they're not worth an awful lot when they get them, then the tax on receipt of those shares is lower than would otherwise be the case. The hurdle's usually set at a level that gives the current shareholders a priority return. And they're very common in PE-backed, private equity-backed companies because those typically don't qualify for EMI options. On the next slide, we talk about what the tax implications of that are. So basically, if you are buying them in at a particular price, you'll pay the difference between what the value you pay and the market value. It will be subject to income tax when you buy the shares. So if you buy them at market value, no tax, but if you buy them at less than that, there is some tax. And then any excess over that is subject to capital gains tax, and you may get business assets disposal relief if you meet the conditions, but there is no automatic entitlement to that like there is under EMI. Just a few practical considerations on the next slide to take account of if you're thinking about growth shares. They are more complicated, so you do need to take a reasonable amount of advice in how you set these up. Great care needs to be taken in the drafting the share rights, because it's not possible to kind of get a blessing from HMRC that you've got it right, and it will be necessary to get some accounting input from a valuation perspective on what the value of those shares are. You can include performance conditions, but there are some kind of complexities if you want to start doing this on a frequent basis and doing periodic grants. And if there is some value in the shares at the outset, you do need to think about how you're going to be structuring that cost being met by the employee and whether it's going to be funded by the employer. So they do take a little bit more planning, and you would need to take advice on it. But it can be a tax efficient scheme. Again, those need to be registered with HMRC. They need to be notified annually, and there are some kind of additional tax elections that you would want to make sure that you had taken account of. So again, the next slide after this one shows the pros and cons, which you can take a look at when we circulate the slides. A couple of bear traps on growth shares that are worth highlighting out of here. A future buyer looking at a growth share will really do a lot of diligence on them. So you do want to get some external advice on valuation. It's not as straightforward as saying there's no value in the shares because you haven't met the hurdle yet. And please be careful if you do have a plan that is set up under a growth share scheme. Footering about with the share rights after those shares have been issued can trigger tax charges at that point without there being any realization of value. So there are a number of things to be aware of if you have set up a growth share scheme. So just having a look to see very quickly whether we have any questions in the Q&A box. Here's one for you, Armando. Can you grant EMI options with an option price which is less than market value when the option is granted?
Yes, you can. So if you want an option holder to participate in some of the existing value of the company as well as future growth, that might be appropriate. Which means that there will be a tax liability on exercise, so that should be considered, as it will be a cost to exercise the option, which needs to be funded.
Okay, and then I think we've got time for just one more. I'll pick this one. We're a family company and we're not looking to sell the company in the future. Is a share plan appropriate for us? So it is more challenging to design an option scheme where there isn't an expectation of a realization event for other shareholders in the future. But it can be done. So you can create internal markets. But you would need to take some care in how you structured those from a tax perspective, and obviously you would need to take some advice on the best mechanics for your particular scheme. But it can be done. It isn't impossible. I'm afraid that's all that we have time for today. For joining us, I hope you found that of some use.